Hello and welcome everyone. I know it's 1 o'clock and we had well over 1,000 people sign up, and we got people piling on here like crazy. So I'm going to give it probably 1 more minute before we start. Just want to let you know you're in the right place, and we'll start in about 1 minute. Thanks. Welcome if you just hopped on and you're here for the top 10 COVID-19 questions answered part 2, you're in the right place. We had over 1,000, well over 1,000 registrants, and the ticker is climbing really fast where we got people coming on. So probably give it 30 more seconds and we'll begin. Thank you. All right, welcome everyone to today's webinar, the top 10 COVID-19 HR questions answered part 2. So last week at this time, we had held a webinar of nearly the same title. It turned out in retrospect to be part 1, where we answered top 10 questions that our HR services team had fielded. Today's webinar is to answer the top 10 categorized questions that resulted from that webinar, as we had several hundred that were unanswered and the interest seemed high. So let me proceed. So real quick, I think most of us have seen a map that looks something like this, right? No secret, the numbers are climbing like crazy every day. 20,000 plus new cases a day, and anticipating this next 2-3 weeks to be really the roughest for the country as we approach the peak. And so naturally, lots and lots of questions, specifically in a payroll HR context. How do we handle this thing, both from a human perspective and from a compliance legal perspective? And so while this has gotten real in this last 2 weeks for, I'd say, probably 2/3 of the country, as we've had the shelter in place orders in place from governors and mayors of the big municipalities and counties, really Washington state, more specifically the greater Seattle area, it was kind of, even though New York is the epicenter of this thing for the US right now, Washington was ground zero for the US. And it's been over a month ago, February 29th, the first person in the US died from this in King County. And so if you look where King County is, this is King County, so you see Seattle, and we have an office right here in Bellevue. So if you look just north of Bellevue, there's Kirkland. That's where the nursing home was, where the tragedy was. Somebody impacted people. And so right literally down the street, Assure has an office that is coincidentally our consulting team, filled with HR professionals that handle HR questions from our clients as a virtual outsourced HR function. And so the team up in Bellevue, I think, is probably a few weeks, if not more, ahead of the rest of the country in fielding HR specific questions on this topic. And that's really why how we've chosen the construct of this webinar. And so the people that we're going to be presenting today, we got Drake Roth, who's an HR consultant, of the Bellevue office. We got Mark, who is a SHRM certified professional. He's a PHRI, a very senior, experienced HR person. Nicole Young, who is a HR compliance manager, has her law degree and focuses on the compliance side. So these are the experienced pros who have a lot of experience, not just in HR, but specifically working with clients from an HR perspective as it relates to COVID. So, excuse me. There we go. So real quick, before we jump in, I want to talk about what's in this webinar and what's not. So what's in, we have added another layer. So last week, the Families First Coronavirus Response Act, the FFCRA, was quite new. And so we touched on it as a topic, but we didn't really share a lot of meat. So we wanted to share a kind of a synthesized version of what is in the law, what does it mean, what employees are eligible, what employers are covered, and walk you through the more details of that. Then we're going to get into the top 10 questions that were unanswered from last week's webinar. Now, if you missed last week's, you can still catch it online. We have a recorded version on our website, and then we're going to have a Q&A period. What's not? So what's on a lot of people's mind is the payroll protection, paycheck protection program that is a subcomponent of the CARES Act that got signed into law end of last week. And this is with the component of the $2.2 trillion in stimulus money. So they are unavoidably linked, the FFCRA and the PPP as a component of CARES. It's a lot of acronyms. And we will allude to it in some places, but just know next week, a week from today, we are going to hold another webinar that will be specifically on the Paycheck Protection Program that certainly has some HR components about tax deferment in reporting, presumably forthcoming reporting requirements that employers are going to have to follow for reimbursement. But it has a lot to do with, how do we get in line how do small businesses get in line for money and compensation, and then what types of loans are going to be reimbursable and whatnot. So a lot of that is very fluid. It's still being figured out. And we'll have a lot more detail to share next week's webinar. The only thing I'll caveat, a bit of a safe harbor note at the bottom, Assure Consulting, Assure HR Help, these are all groups within Assure. These are HR pros. So Drake, Mark, Nicole, very seasoned, very experienced, very talented HR specialists, and they're here to give guidance and advice, but it's not legal advice. You should always still consider and consult with your local authorities because HR law is regional, right? States administer unemployment. States and municipalities have their own HR laws that you must follow. So we're giving our best advice and guidance, but do seek the legal counsel of your CPA, your lawyers, your bankers, anybody local to ensure that you're compliant with local law. The last thing I'll say before I hand it off to Nicole is no sales pitch. We've developed a website, assuresoftware.com/COVID-19. We're trying to put as many resources here for you guys as possible. So we've just on Friday published the Small Business COVID-19 Survival Guide. So it's all about HR and payroll best practices for really surviving in the COVID-19 pandemic. Things, how do you disaster-proof your payroll HR function, for example. And then there's a recording available free of charge for last week's webinar that you can access, just like you'll be able to access the recording from today's webinar from that same site. We also have Department of Labor guidance on the Families First Act, payroll and HR best practices. And we'll hit it again at the end here, but we have one blog post that all it is links to all 50 states and a bunch of the major municipalities for their COVID-19 sites. So you don't have to hunt to find what are the resources available in your local area and what laws must you comply with according to those government sites. So with that, Nicole, I'm going to turn it over to you to take us through the details, requirements, and eligibility for Families First Act.
Great, thank you, Mike. I appreciate that introduction. So getting started, obviously no one expected this situation to happen. And so things are gonna be fluid right now. The name of the game is flexibility and agility. I frequently told clients, look, I'm giving you this advice today. It may be stale tomorrow. In order to react to the pandemic that's going on, the government has released a bunch of new laws. They were drafted very quickly. The Families First Act, which we are going to discuss today, doesn't even have regulations out, and it is effective today. Normally with a big law like this, we not only have regulations, but we also have case law that's deciding certain areas that are ambiguous. And obviously we don't have the benefit of that right now. So as a result, we're gonna have a lot of ambiguous areas, and I will tell you about those. Luckily, I think in anticipation of this, the Department of Labor has said that they're gonna have a 30-day non-enforcement period for companies making a good faith effort to comply. But just so you know, going forward, there are gonna be some gray areas. So a little bit about ASSURE's participation in this. We participate in a consortium, and our job is to coordinate with governing bodies like the Department of Labor to help sort of give our input on standards and rules. We work with other payroll companies like ADP and Paychex, and we sort of have a board seat to consult with the IRS and the Department of Labor on some of these rules. So we sort of have an inside perspective on a lot of the changes that are being made. So just briefly, the Families First Act, it requires paid sick and family medical leave for certain reasons related to COVID-19. In this presentation, I'm going to give you a brief overview with my colleague Mark. We're going to go over who is covered by the law, which businesses are covered, which employees are eligible to take the leaves, how long each type of leave lasts, and how you're going to calculate employee pay during these leaves.
So let's start with the basics. Hello, everyone. So what does the FFCRA provide? It provides funding to federal agencies. Some of those, Department of Agriculture, Health and Human Resources Services, Department of the Treasury, Veterans Affairs, etc. This is a very incomplete list. There's a lot of agencies it supports. It also provides nutrition waivers for students in response to school closures, emergency unemployment insurance. It's funding provided to state agencies. There are some strings attached aimed at increasing access to unemployment insurance. Health provisions, Medicare, Medicaid, private insurance, testing, diagnosis, covers all that stuff. As it applies to you as employers, there are 3 provisions which directly affect how you run your business: the emergency family medical leave, the emergency paid sick leave, and tax credits for wages provided under these laws. There's a lot there.
Yes. Yeah, so one thing I got to say for those my fellow HR practitioners out there, terrible acronym. We are one letter off from the Fair Credit Reporting Act, and so it's not my favorite, FFCRA. But just very quickly, the Department of Labor Wage and Hour Division administers and enforces this act. The reason why we should care about this is if you have any questions going forward, consult with the Department of Labor website. So far, they have released several documents. First, they've released a employee rights poster, which is a requirement to hang in your work site and to send to employees who are teleworking right now. They've released guide sheets for employees and employers that explain the law. And they've also released, and they've been continually updating, a very extensive frequently asked questions page. The one thing that we haven't gotten yet is the regulations. So this law is effective today, and it's going to end at the end of this year. And we will go over what this means for employee leaves later in the presentation. One other quick thing I want to bring up is for those of you who have 50 or more employees, this act amends regular FMLA as you know it. What this means is that if something is not mentioned by the Emergency FMLA Act, you can look to the regular FMLA law for guidance. Now, of course, consult with legal counsel, but this is a good rule of thumb to know that Emergency FMLA amends regular FMLA. Now, in terms of emergency paid sick leave, this creates a new leave system. And so if you're in a state that already has some type of paid sick leave provision, these are two separate state and federal systems. So if you're looking for guidance for emergency paid sick leave, do not consult with your state leave law.
So which employers are covered under the EFML and EPSL? It's employers with less than 500 employees. Why? Why that threshold was chosen? Not 100% sure. One of the reasons that we know of is that larger businesses are assumed to already provide paid sick leave for the reasons that are going to be discussed. They also did not want companies with more than 500 employees to receive a tax credit. So, who's an employee? Anyone who is on the employer's payroll. Anyone. Individuals working for and receiving wages. Individuals that are on leave are also to be counted. Temporary employees if the employer is a joint employer with another entity, like a temp service or things like that. That is regardless of whether the employee is on your payroll or on another employer's payroll. Who isn't counted? Independent contractors. Look at your state rules for guidelines on what is an independent contractor. Anyone who has already been laid off should not be counted. So, when do you measure that head count? It's at the time the employee decides that they want to take leave, and if there's a lag time between the request leave that they actually go on, go with the leave time.
Yes, so there are certain exemptions for small businesses. The rule is if you have a small business that's fewer than 50 employees, you can claim an exemption for employees who are taking leave to care for a son or a daughter. So this exemption covers emergency paid family medical leave and a portion of emergency paid sick leave. Within the law itself, it says that this exemption is available if offering this type of leave would jeopardize the viability of the business. So the law itself does not clarify what this means. However, the Department of Labor recently released some frequently asked questions that go over, okay, what is the meaning of jeopardize the viability of the business? And it breaks it down into three possibilities. First, the officer of the business determines that providing this type of paid leave would result in expenses that would exceed your business's revenue and cause the business to operate at a minimal capacity. Another possibility is that this employee is sort of a key employee, and if they go out on, let's say they're taking 12 weeks of emergency FMLA, if they leave, it would present a substantial risk to the health of the business because this particular employee has specialized skills and you need them around. The third reason is sort of a flip side of the second reason, and that's if you offer this type of leave to an employee, there aren't enough sufficient workers available to cover the person who is taking the leave. So in other words, we can't hire a temp and we need this person around for their specialized skills. So to break it down, jeopardize the viability of the business means we need this money or we need this particular person in that job. So for nonprofits, this law should apply in the same way. The only sort of way it could affect nonprofits differently is that different taxes apply to nonprofits. And so it could affect your ability to obtain a tax credit for wages paid out through EPSL or EFML. One thing I want to clarify, I've heard a lot of business discussing, clients discussing this exemption for small businesses and using language of, oh, well, we can get an exemption if it's a hardship on our business. And I just want to clarify, I think people are used to using the word hardship or undue hardship in relation to the Americans with Disabilities Act. And I want to clarify, this is a different test and this is a more stringent standard when you're seeking to use this exemption. Oh, and sorry, Mike, before we move on, one other thing I want to mention. Coverage is important because it has huge implications for tax credits. So let's say that you're above the 500 employee headcount and you say, oh, we want to offer leave under these laws anyway. You may not be able to get reimbursed from the IRS for payments made under this law. And so you really want to be careful. A lot of employers are oscillating between fewer and above 500 because of all these layoffs. So if you are below 500 at the time someone is taking leave, you can receive a tax credit for that payout. But if you are above 500 at the time someone is initially taking their leave, you may not be able to receive that tax credit. Okay, so which employees are eligible to receive emergency family medical leave and emergency paid sick leave? So there's different standards for both of these types of leaves. For emergency family medical leave, it's employees who have been employed for 30 calendar days. Now, what this means basically is someone who has been on your payroll for 30 calendar days. Now, the CARES Act actually amended this provision to expand eligibility to employees who have been laid off. So the rule under the CARES Act is if you have an employee who was laid off recently from March 1st, 2020 on, and before they were laid off, they were employed with you for 30 days within a 60-day period. And if they were rehired after being laid off, they are eligible for emergency family medical leave. Now, please note, someone who is on a layoff and who hasn't been rehired is not eligible. And one other thing to note as well, if you just have a regular employee who has not been laid off, they need to be employed for 30 continuous days. That 30 days within a 60-day period, that only applies to employees who have been rehired. Otherwise, the person needs to have been with you for 30 continuous calendar days.
So what about emergency paid sick leave? There's a couple of things. There are 6 reasons why an employee could qualify for this. And those include you're subject to a government order, the quarantine, isolate, and you can't work during the quarantine isolation. It's listed on the website for the DOL. And so there's 6 reasons for that. Does part-time versus full-time status? Yeah, it could. The 6 reasons are government shelter order related to COVID-19, healthcare provider advises employee to self-quarantine, experiencing COVID-19 symptoms and actively seeking a diagnosis. That's critical. Employee caring for an individual experiencing reasons 1 or 2. Child care, same reason as the emergency family medical leave. And employee experiences substantially similar condition. So what kind of documentation? There's a number of things that we can do there.
So Mike, I think we may have skipped over a couple questions in the last slide. Would you mind moving back one slide, please? Thank you. So I just want to clarify for everyone, emergency paid sick leave is available to all employees. So if you have, and below, one of the questions is, does part, and I've gotten this from a lot of clients, does part versus full-time status affect eligibility for either of these? And the answer is no. For emergency family medical leave, all that matters is that they've been on your payroll for 30 calendar days, regardless of whether they're working 40 hours a week or some increment that's lower than that. In terms of part or full-time status for emergency paid sick leave, it does not matter. They are still entitled to receive the leave. Now, part or full-time status may come into play in terms of how many hours of paid sick leave they're receiving or how much pay they're getting under either law, but it should not affect their eligibility to receive these types of leaves. In terms of temporary employees, if they're employed by a temp agency, generally they're not eligible for emergency family medical leave or emergency paid sick leave. But let's say you have an employee who was a temp and you hire them on full-time. In that case, the time worked as a temp would count towards the 30-day eligibility period for emergency family medical leave. In terms of any exemptions for eligibility, as the law is written, it provides exemptions for healthcare workers or emergency responders. The reason being, obviously, our lawmakers want to have those people continue working through the pandemic. All right, we can go to the next slide. Thank you, Mike. Okay, so for what reasons can an employee take emergency family medical leave or emergency paid sick leave? For emergency family medical leave, there's only one reason an employee can take this type of leave. I broke it down into a bullet point list so that it was easily digestible for all of us here, but this is all one reason. So the first factor you need is that the employee has a son or daughter that's under 18 years old. Their school or daycare has been closed due to COVID-19 reasons. There's no alternative care, child care available, and caring for the child prevents the employee from working. And I think this last portion is one of the more important pieces. I think, so if we think about this from a practical perspective, how this will likely play out is employees who are working on site and need to be on site are more likely to need to use this type of leave. Because if you have an employee who's teleworking, typically those employees are able to care for their child while simultaneously teleworking. I know for a lot of us, unfortunately, that is the current situation. But of course, there could be exceptions to this. Let's say that an employee has a child with severe developmental disabilities and they need constant attention. In that case, they may not be able to telework while caring for the employee. So be sure to talk to your employees and find out particularly, if all these factors are true. Do you have a son or daughter under 18? Has their school or daycare closed? Do they have alternative care available? And why does caring for the child prevent them from working? In terms of the emergency paid sick leave reasons, I know that Mark touched on these. I just want to clarify number 6. The law says, let's see here. The law says if the employee experiences a similar condition as specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. What does this mean exactly? I like to think of this as a catch-all and for a what-if situation. So until we receive further guidance from Health and Human Services on whether a substantially similar condition arises, we should just treat this as sort of, we're going to ignore it for the time being. But it's sort of a catch-all because things are so unpredictable. They wanted to have this available because we're not sure what's going to happen next. In terms of what documentation we can require for each type of leave request, it depends on the reason for leave. For some of these, you won't be able to get documentation, but the frequently asked questions section of the Department of Labor has clarified that you can ask an employee to provide a notice that the child's school or daycare has been closed. So notice is sort of a flexible term. It could be a letter from a school official. You can ask an employee, I think the largest one is for a doctor's note, if they've been advised by a healthcare provider to quarantine themselves, or if they're seeking a diagnosis. So let's say you've got an employee who's sitting in the waiting room and they want to receive emergency paid sick leave for reason 3. They're experiencing symptoms and they're seeking a diagnosis in the waiting room. In that case, I might ask the employee, hey, can you get some sort of note from a doctor or a nurse working there that sort of clarifies that you are seeking a diagnosis at this time?
However, also remember, oh, sorry, go ahead. Remember at this time, healthcare system is really overloaded. So getting that documentation may or may not happen. We can ask, doesn't mean that we'll always get it as requested.
Yes, that's true. And I want to clarify, one of the questions down here is, what if an employee has a qualifying reason for leave but is teleworking? In that case, they are not able to they can't take EFML or emergency paid sick leave. These laws come into play where someone is prevented from working for one of these reasons. So if they're able to telework, they don't get access to these types of leaves.
So how much EFML can an employee actually use? They can use up to 12 weeks. Now the question becomes, does regular FMLA use drain EFML leave, bank and vice versa? The answer to that is yes. An employee is only allowed 12 weeks of FMLA under either one in a 1-year time frame. There may be some additional guidance towards the end of the year because remember, this law is going to sunset at the end of the year. So what if someone takes leave in November? We'll have to cross that bridge when we come to it.
So in terms of emergency paid sick leave, the amount of leave available is going to depend on the employee's status with you. If they are full or part-time. Full-time employees are generally those who are regularly scheduled to work at least 40 hours per week. And part-time employees, for the purposes of this law, are classified as those who are scheduled to work fewer than 40 hours per week. So the lawmakers basically wanted to provide employees with 2 weeks of leave. So for full-time employees, this means they get 80 hours of leave because they are regularly scheduled to work 40 hours per week. And for part-time employees, the number of hours they receive is going to be the average over a 2-week period. Now, the law doesn't specify, and I've heard this question from clients. Okay, what 2-week period are we talking about here? I've heard I have a seasonal employee, and they aren't even working for half the year. Which 2-week period do I use to calculate this? So the Department of Labor has clarified if you're trying to come up with an average number, you can use a 6-month period to form an average of number of hours an employee works over a 2-week period. And if your employee has not worked for you for 6 months, what you can do is say, okay, what was our understanding with this employee when they were hired for the average number of weeks they would work? So for example, let's say I recently hired an employee and I said, you're going to work on an average, we want you to work 15 hours per week. I would use that in determining how much emergency paid sick leave to grant them. So one question I've gotten is, how does the expiration date at the end of the year affect leave entitlement? Basically, when that comes around, it's going to cut off all emergency family medical leave and all emergency paid sick leave. Even if someone hasn't used up their full 12 weeks or their full 80 hours, let's say they start leave in November, it's going to cut off at the end of the year. So leaves do not carry into 2021, even if they start at the end of 2020.
What is the regular rate of pay? There's a couple of things for emergency family medical leave. The first 10 days of this leave is unpaid. Remember, there's also EPSL. The remainder is 2/3 of your regular rate of pay, but there's a cap. It's up to $200 per day, $10,000 for the entire leave. So what is the regular rate? The regular rate for your non-exempt employees, these are the ones who are typically considered hourly, is going to be the regularly hourly rate of pay. For salaried exempt, it's whatever they get paid during a work week, the pre-established amount. Their regular salary.
Okay, so I just want to clarify on that. The first 10 days of EFML are unpaid. Your employee has the right to use emergency paid sick leave during this time, but you cannot force them to take it. So if they decide, you know what, I want to save my emergency paid sick leave and I'm going to use it at the back end of my emergency family medical leave, that's their right. This is different from emergency family medical leave, which you as an employer have a duty to start on the behalf of the employee. So the employee is empowered to use emergency paid sick leave when they would like to. Emergency family medical leave, once it's triggered, the employer has a duty under the law to start that leave. So going over employee compensation for emergency paid sick leave, the amount that the employee is going to be paid is going to depend on their reason for leave. So if they're taking leave for reasons 1, 2, or 3, and that's written on our previous slide, but just very briefly, if the employee is subject to a government order to quarantine, if they've been advised by a healthcare provider to quarantine themselves, or they have COVID-19 symptoms and are actively seeking a diagnosis, then they're paid at their regular rate of pay with caps. The caps for these types of, for these reasons for leave are $511 per day and $5,110 for the entire leave. Now, if an employee is taking leave for any of the other reasons, so if they're caring for another person who is subject to a government order, been advised by a doctor to stay home, then they're paid at 2/3 their regular rate of pay. And the caps are slightly lower to $200 per day or 2,000 for the entire leave. One little trick I use to try and remember, okay, how much should I be paying this person for emergency paid sick leave? I think to myself, are they taking leave for themselves or are they taking it to care for another person? If they're taking it for themselves, then they're paid their full rate. If they're taking it to care for another person or to care for a son or daughter, it's going to be 2/3 their regular rate. And one thing I want to note is one of the questions down below is, can we pay our employees more than cap limits? You certainly can. These are, of course, lawmakers are always, want to encourage employers. If you want to offer something more generous to employees, that is certainly not against the law. However, a word of caution, if you do go above the caps that are written into the law, you're not going to receive tax credits for anything that goes above and beyond. So if you want to receive the dollar for dollar tax credit, you got to stay within these caps.
Great, thank you, Mark and Nicole. So that brings us into, kind of the FAQ portion of the webinar. This is Drake, by the way. Hello, everyone. Thanks for joining us today. So this is going to cover some questions that we've received, regarding, everything we just talked about and some of the information we covered last week. So I'm just going to move right into question 1. So all of this information is great. FFCRA, I'm starting to understand it more, but it's a little late. I've already made some decisions to lay off some employees before all this was passed. Do I need to bring them back and offer all of these leave options if they qualify for it?
That is a great question. So the answer typically is no. It's only available to current employees, as we talked about earlier. If you have temporarily laid someone off and are bringing them back, you can assess at that time that you're bringing them back whether they would qualify for EPSL or EFML, depending upon how long they've worked, all that good stuff that's in there. Go on to the next. There we go.
Next question. So how do I, if I'm a small business, where do I go to qualify for these small business exemptions, or what exactly, are the qualifications for, being a small business and getting that exemption under EFML and EPSL?
Sure. So I will start this answer by saying that I am fairly confident we're going to receive more guidance from the Department of Labor when the regulations are released on the specific procedural requirements for the exemption. But for now, just to review, the exemption is available for employers with fewer than 50 employees. It's available if the employee is taking leave to care for a son or daughter whose school or daycare has been closed. It's only available if providing this type of leave to your particular employee would jeopardize the viability of the business. So far, the Department of Labor has told us you do not need to apply for an exemption, but instead, at this time, if you decide, look, we can't offer emergency paid sick leave or emergency family medical leave to this person who's to care for their son or daughter, you should document why. And this may be because later on they're going to say, oh, we do want to see some sort of documentation from employers who aren't offering this. This could be, as terms of thinking as a lawyer, I always say documentation is the best way to go. And so if you do have an employee who turns around and sues your business because you didn't provide them this type of leave, it's always a good idea to document your reasoning for your decision. But for now, let's wait and see for further guidance from the regulations on small business exemptions.
All right, so our next question. These laws just passed. I'm still figuring out, the nuances of all this. I have some employees who, have kind of already worked out an arrangement for childcare or whatever their private responsibilities will be. Do I need to offer them the full leave? Could I offer them intermittent leave to line up with the, scheduling they've already figured out in their private lives?
So that's a great question. There's a couple of things. Yes, intermittent leave is available. However, there are some requirements that need to be met. So it's not required under the law. However, if you do offer, there's some certain requirements. If you're offering it to employees who are working on site, you can only offer it in full day increments. But it doesn't apply to teleworking employees. If offering intermittent leave to employees who are teleworking, It can be taken in any increment agreed to by you, the employer, and the employee. On-site employees can only take it, others can take it only to care for a son or daughter whose school daycare has been closed and there's no other care available. This again does not apply to teleworking employees. If offering intermittent leave to employees who are teleworking, it can only be taken for any reason agreed to by the employer and employee.
Yeah, so just a little more clarification on one of the requirements. So under the law, they're only going to permit on-site employees to take intermittent leave to care for son or daughter whose school or daycare has been closed. And just in case anyone is scratching their head on what does intermittent leave mean? It means that you're not taking emergency paid sick leave or emergency family medical leave as one continuous chunk. Maybe you're taking a day on Monday and then a day on Wednesday. The reason they don't want on-site employees to take intermittent leave for any of the other reasons is because they want to reduce the spread of the virus. So the other reasons people can take emergency paid sick leave are they've got symptoms or they're caring for someone with symptoms. And obviously we don't want people coming to the work site if they have COVID-19 symptoms. And so in that way, the lawmakers thought, okay, we're gonna allow people to take intermittent leave for these other reasons only if they're teleworking. So an example might be for this, let's say you have an employee with COVID-19 symptoms, but they're extremely mild and they can continue work and maybe they're tired at the end of the day and so they need to take a few hours of leave at the end of the day. In that situation, you could offer them intermittent leave, allow them at the end of the day to take emergency paid sick leave for their COVID-19 symptoms if they're actively seeking a diagnosis as well. Just some considerations when you're designing your intermittent leave policy. If you're working within these requirements in terms of full day increments to employees working on site and only offering intermittent leave for those caring for a son or daughter for on-site employees, otherwise you're given considerable discretion on how you want to design this policy. So if you want to say to your employees, okay, we're only going to offer intermittent leave to people who are going to be working on site because we have less control over employees who are teleworking. You are permitted to do this. The one word of caution I want to tell everyone is if you are designing a particular type of policy, you need to ensure that it's not implemented in a manner that's discriminatory towards certain people. So just as an example, let's say you do have, this is just, we're working in a fantasy world here where most of your employees who are on site are men and most of your teleworking employees are women. If you decide we're only going to offer intermittent leave to on-site employees, it's going to have a disparate impact on a protected group, which is your female workers. So just be aware of that when you are designing a policy. Also, let's say that your policy is going to be, we're going to permit a certain manager to have discretion over who he or she wants to give intermittent leave to. Be sure that your manager is offering intermittent leave in a way that is justified by business reasons. We don't want managers just saying, I like this particular employee more than this other employee, and so I want to give them intermittent leave. No, it should be reasons such as, we need this employee on call certain hours, and so we want them to take intermittent leave as opposed to continuous leave. When you are creating this type of policy, you should keep in mind that one thing you can offer as an alternative is using an alternative schedule instead of intermittent leave. So in this situation, you would agree with your employee to offer a new schedule with different hours of work in order to accommodate their needs. So let's say you have a mother who has to care for a child from like 1 to 3 p.m. in the afternoon. Instead of saying, okay, you can take emergency family medical leave from 1 to 3 in the afternoon, you could say to her, hey, what do you think about maybe shifting your hours so that you work early in the morning to make up that lost time? And that is available as an alternative to intermittent leave.
Excellent. Let's move into our next question. So with all of these different types of leave, with all these changing, rules, I still have business considerations. Is there any sort of job protection or other continuation of certain privileges that I'm obligated to provide to employees who are using this leave?
There are some particular carve-outs for the EFML. I'm going to speak to what regular FMLA rules require. They require that you bring the employee back into a same or similar position as the employee held on the day before the leave commenced, with similar pay authority, in other words, conditions of employment. Whatever they're doing before they left, it's got to be something similar. Second, you also have to continue the benefits, medical, dental, all that good stuff, as if they were still working there at your site. The employee is responsible for paying their share of any premiums, if there are any that they are responsible for.
And just really briefly, there is a carve out for smaller businesses under EFML where job protection may not necessarily apply if you have fewer than 25 employees. There are conditions that go along with that in terms of reaching back out to the employee if you lay them off and the position reopens. But just be aware of that. If you do have a business with fewer than 25 employees, you can look into the job protection carve out for your organization.
Great, thank you. So really quick, we just want to run through a few kind of hypothetical questions. It's kind of a lightning round, so to speak. So hypothetical one, we have an employee working from home, they have a cough, may or may not be, specifically COVID related. What are the options? How do we even go about, addressing this?
If they can work from home, encourage them to do so, because it could be COVID-19, could be allergies. We're in the middle of allergy season. There is a duty under OSHA for the employer to provide a safe and workplace for the employees that are still there. So they have a cough. It's one of the symptoms. They may need to be encouraged to say, you know what, stay home for a couple of days, see what happens.
And just from a legal perspective, now that the Families First Act is effective, they could qualify for emergency paid sick leave. One of the reasons for emergency paid sick leave is the person is experiencing COVID-19 symptoms and is actively seeking a diagnosis. So you can ask the employee, have you called your doctor? Are you making any steps to seek a diagnosis at this time? And if they are, you could offer emergency paid sick leave to them. Now, the employee doesn't necessarily need to take emergency paid sick leave. They could take, if they have a PTO bank or any other, if you have some sort of state paid sick leave law, they could take that in lieu of emergency paid sick leave. But let's say, just running with this example, if the condition becomes serious, you might look into potentially FMLA coming into play or any sort of state family medical leave law coming into play. If the employee is ineligible for either of these types of leaves, I would treat time off for them as an ADA accommodation if their condition becomes serious.
Right, on our next question, we have an employee, they were exposed to COVID-19 at the workplace. What are the employee's options and how do we even go about addressing this with the rest of our workforce?
So a couple of things. One, you have to keep the information confidential. So tell the other employees that, hey, you may have been exposed. You may want to get checked out. You may want to stay home. Again, all the options are available, EPSL, PTO potentially, that they can take, but we want them to protect themselves. Secondly, as the employer, again, you have to have that safe workplace. So take steps to ensure that people are cleaning their desks, using hand sanitizers, things like that, and see what develops. They may want to stay home, seek an active diagnosis, all those reasons that we discussed earlier.
So I also want to clarify for everyone, emergency paid sick leave can come into play in a situation like this. Reason 2 for emergency paid sick leave is an employee has been advised by a healthcare provider to quarantine themselves because of COVID-19. So let's say in a situation like this, one of your employees was exposed to COVID-19. There's nothing stopping them from going to a healthcare provider and telling them what happened and asking for some sort of note with a quarantine advisement. And if they do receive a note like that, you could offer them emergency paid sick leave in that situation.
Right, moving into the next hypothetical. I have an employee who's disclosed to me they have a roommate or housemate that, has COVID-19. How do I address that?
So again, they've been exposed. So if they're not experiencing symptoms, you can encourage them to say, hey, you know what? You might want to consider staying home. Again, they could be eligible for the EPSL. It all depends on that situation. The answer really is depends. Need more information. I've got someone that I'm in close contact with who's got COVID-19. Obviously, they've been exposed. They may need to go and seek medical advice.
Yeah, so some concrete steps I might take in a situation like this is I would notify the rest of the workforce, and I would make sure to do it in a way that doesn't give away who potentially may have COVID-19, because that would run afoul of the Americans with Disabilities Act. So I might send out an email and let people know, just as a precaution, one of our employees may have been exposed to COVID-19. If you have any questions about this, please contact me or give a call to your medical healthcare provider. If, let's say, an employee tries to go to a healthcare provider and manages to get a note advising them to quarantine themselves because of potential exposure, emergency paid sick leave could apply in this situation.
Right. This next question here is very important. Let's say I'm a business owner in, Florida who just got, shutdown orders today or isolation orders today. How do I handle this, given this government shutdown order after this, active date for the Family First Act?
Sure. So we're seeing this all over the place. If your worksite closed before today, so before the effective date of the law, and as a result of the closure, a huge portion of your workforce or all of your workforce was laid off prior to the effective date of the law, they can obtain emergency paid sick leave or emergency family medical leave. Even though one of the reasons to take emergency paid sick leave is a government order to quarantine or isolate, in this situation, they're no longer employees. They've been laid off before the law was effective. And so instead, these employees should file for unemployment rather than using emergency paid sick leave. So let's say that there's a situation where you have a business closure and it is after the effective date of the law. So I have heard from a lot of my colleagues that the reading of government order to quarantine or isolate is a very specific reading that an employee has been advised by the government to quarantine themselves. A lot of attorneys I've talked to are not reading shelter-in-place orders as a government order to quarantine themselves. And so I just want everyone to be careful. If your business does shut down because of a shelter-in-place order, you may not necessarily need to offer them emergency paid sick leave. I would also advise once the Department of Labor regulations are released, we may get some more information on this issue, and so we should look to those for further guidance.
Excellent. So moving into our last two questions here. Reading the laws, knowing best practices is great. From a more practical standpoint, how do I go about administering these emergency leave options?
Ooh, this is a big question, but I'll touch on some hot points here. First, I would make sure that you set up your payroll and keep emergency paid sick leave separate from employees' other forms of paid time off. So you need to keep it separate from regular PTO or vacation. In addition to if you're offering your employees paid sick leave under a different state law, emergency paid sick leave must be maintained in a separate bank. I would make sure that when you're administering emergency paid sick leave, you maintain any sort of documentation you receive from the employee for their leave in case that's needed for the tax credit application. You should consult with the IRS on the applicable paperwork needed. That hasn't been released yet, but just that's something to keep in mind. And one other thing to keep in mind for administering emergency paid sick leave is that, and I've touched on this, but it is the employee's choice on whether they want to take it. You cannot require an employee to take emergency paid sick leave. Now, what do you do if an employee doesn't want to take emergency paid sick leave and they have no other form of paid time off available? Unfortunately, in that situation, you would need to go the disciplinary route. And if an employee refuses to use a protected form of leave, you can discipline them for an unexcused absence. Really briefly on emergency family medical leave, I would keep these leaves in the same leave bank as your regular FMLA leaves if you have over 50 employees. Because as Mark said earlier, if you use emergency family medical leave, it's going to dwindle the employee's regular FMLA bank and vice versa. Similar to emergency paid sick leave, I'd make sure you maintain any sort of documentation you receive from the employee. So a note from the school or school official about the closure. Just one last point, the employer has a duty to start emergency family medical leave when they're put on notice that the employee could qualify. So this is different from emergency paid sick leave. It is not the employee's choice on whether they can take emergency family medical leave. The employer, after being notified of the reason, needs to start that process. And I'm sorry, one other thing I want to mention, we're cautioning our clients, do not use the regular FMLA paperwork for emergency family medical leave. So as we know, when you start an FMLA leave, you need to send the employee a rights and responsibilities notice, a certification, a designation notice. We are saying for the time being, do not use that paperwork for emergency leave. So I will turn it to Mark for the HR side of this.
From the HR side, real briefly. So decide on what your policy is going to be, how you're going to do it, who's going to manage it, how are we going to track it, things like that. If intermittent leave is going to be offered, how will it be offered? Are alternative schedules, as Nicole talked about earlier, is that available? Increments used. This could be determined by your payroll system. Could be 15 minutes, could be an hour. And definitely assign a person in charge with receiving and tracking leave and educate your managers on how this will all work. It's going to happen pretty quickly. There's a lot to do there.
All right, and moving into our last question, which is very open-ended. I'm in Chicago, and we have very specific laws to our municipality. I'm in LA. We have predictive scheduling laws. How does this all interact with it? I'm in New York. How does all of this interact with, Bill 8091 that was passed last week? How do I juggle all of these state-specific laws?
Yes, so we have been discussing a federal law throughout this presentation. If you have a question about the particular state you're in, you're going to need to consult with your state's resources and also your municipality's resources. Every state has its own requirements for many of these issues, and you need to recognize that Family First is going to work in conjunction with state leave laws. If you ever have a situation where you have different requirements, whether it's on the state versus municipality or the state versus federal level, a good rule of thumb to follow is that you need to follow whichever law is most favorable or generous to the employee. So my recommendations is consult with your state's employment department. We're providing a link in this presentation with a complete list of state and municipal websites that link to COVID-19 resources. But just make sure whenever you're making a decision, you are checking federal, state, and municipal laws for compliance.
All right, Drake. I know that that went longer than expected, so we're basically at the top of the hour. We planned on having a Q&A. I think that was a lot of really awesome information, Mark and Nicole. So thank you. Let me kind of paraphrase as I'm going through. I mean, there's probably 200, maybe 300 questions here. I'd put them in a couple of buckets. One bucket is there a lot of stuff around the PPP, around the payroll, the Paycheck Protection Program as it relates under the CARES stimulus bill. So we're doing as much research as we can, as fast as we can. This thing passed on end of day Friday. And so if there's 48 business hours here. As I've talked to, it's about 4 different banks, 2 different CPA firms in our preparation to try to get some content for today. We really drew the conclusion, and not the conclusion, just directly from those sources. Even though the bill has passed, It's an SBA loans. What everybody cares about is how do we get some of the emergency money, because I know many small businesses are literally in the fight for their life right now. The SBA has simply not provided the guidance to the banks. As of yesterday, all banks that I spoke to thought it was going to be about a 2-week wait before they got guidance from the SBA. That was the expectations they got from SBA. They all assumed that was a hedge at 2 weeks, and it would be probably inside of a week. I understand that late yesterday, some documentation was provided to the SBA lenders, the banks themselves, on what information is going to be needed to be gathered through an application process. But the back end for the bank to work with SBA and get approval and distribution is still not defined. I know that the banks are still waiting all that information. So that's a mouthful to say. This is really, really fluid. We are going to have a webinar a week from today on this topic that we're going to share as much as possible. My assumption is we're going to have a pretty clear picture. No doubt there will be lots of open-ended issues, but we'll have a pretty clear picture on exactly where to point you, who qualifies, what's reimbursable, what are you going to need to do for reporting. I suspect we're going to have probably an 80% picture that we'll be able to share with you next week. And so by all means, check out the suresoftware.com/COVID-19 website. As we have new learnings, we're not going to publish any theories or our best guesses. We're only going to publish trusted sources, documented processes that we understand to be clarified and true. So look there for a constant source. And I think maybe I'll just throw one question out to Nicole and Mark. If you have two employees working for 2 different employers, both take expanded FMLA leave to take care of children, one of those employees is teleworking and they cannot handle it any longer, are they eligible? Or if one parent is teleworking, is the spouse eligible if they can telework? It's complex, nuanced question, but maybe talk about the impact of spouse with these shelter orders. Everybody's teleworking. Can.
Yeah, and I've heard this question before, and it is tricky. I am sure we're going to see something in the regulations that clarifies, alternative. If you have a spouse available who can watch the child, then you shouldn't be entitled to receive leave, because there's something similar to that in FMLA. But the issue is, how are you going to verify the situation? Because you may have an employee who says, I need to watch the child, and my spouse is working, but you have no way of knowing if that is true or not. And so unfortunately, we're going to have to go off of, just good faith. Our employees are telling us, look, I have no other childcare available and I need to care for my child, because there's not going to be a way of verifying whether that's true.
All right, Nicole, I appreciate it. We're over on time, guys. I know there's a lot of unanswered questions. I would encourage you to come back to the site tomorrow where you can get the recording of this webinar, share it with whomever you like, re-listen to it again and again. We're here to support you the very best we can, and thank you everyone for your time. Hopefully we see you next week on the PPP CARES Act webinar. Thanks, bye-bye.